Welcome to our deep dive into the sometimes pretty complex world of construction payments. Ever wondered how just the wording in an email, maybe an invoice, could kick off a massive legal fight? We're talking potentially hundreds of thousands on the line.
Absolutely. And today we've got a really good example, a recent UK High Court case that highlights exactly that.
We're looking at Formations Ltd v. Lapp Industries Ltd. Basically, a contractor got awarded a pretty hefty sum, even though the paying party said the payment application itself was, let's say, unclear, full of ambiguities.
Yeah, and our mission here is to pull out the key takeaways from this judgment. It really shines a light on the incredibly strict rules, sometimes called draconian, around construction payments in the UK.
So you can understand what it means if you're dealing with contracts, invoices, how just missing one step can lead to major financial pain.
Exactly. It's all about understanding the process and the potential pitfalls.
Okay, let's set the scene then. It's 2022. Lapp Industries gets hired by First Formations for some refurbishment work. A property on Shelton Street in London. Sounds pretty straightforward, right?
On the surface, yes. A typical construction project. But there was a catch. A big one, actually.
Which was?
The contract they signed, it didn't have any specific payment terms written into it. None at all.
Ah. And that's not just a minor detail, is it, in UK construction law?
Not at all. It's fundamental. Under the Housing Grants, Construction and Regeneration Act, the Construction Act, as it's known, if your contract is missing payment terms.
The law steps in.
Precisely. A statutory framework called the Scheme for Construction Contracts 1998 just automatically applies. It fills in those gaps as implied terms.
Yeah, so the scheme became the rule book for payments in this case.
It became the entire foundation for the dispute, yeah. Without it, the situation would be very different.
Right, so the scheme is now governing things. What happens next?
Yeah.
LAPP carries out work.
Fast forward to April 14th, 2023. LAPP sends an email, attaches some documents, and they state quite clearly this is their application for an interim payment.
Okay, let's dig into that application. What did the email itself say?
Well, LAPP's Mr. Harris described it as just that, an application for an interim payment for the Shelton Street job. He mentioned the amount was based on a provisional valuation and that it may be subject to any agreed adjustment. But then, critically, he requested a specific payment on account of $100,000 to cover costs while they ironed out the final details.
So a specific sum requested, even with the provisional tag?
Yes. And he stressed needing prompt payment, to cover staff, materials, finance, VAT, the usual pressures.
Okay, and the attachments, were they consistent with that £100,000 request?
Well, this is where it gets a bit layered. First, there was an invoice for exactly £100,000 plus £20,000 VAT, total £120,000.
Clear enough, 120K.
And it said payment due within 14 days from the date of this invoice.
Okay, what else?
Then there was a second document, a detailed breakdown. It looked like essentially a final account valuation for all the work, and that totaled a much bigger figure. £588,590.60.
Oh, right. So a big difference between the invoice amount and the total valuation.
Exactly. And then a third document. This one was actually headed Application for Interim Payment.
Okay.
It stated the value of work carried out matched that big valuation figure, $588,590.60 a year. It showed previous payments received, $303,712, and it calculated a total payment now due of $341,854.32.
So that document pointed to $341K being due, not the £100?
Well, yes, it showed that calculation, but then, confusingly perhaps, right below that it reiterated payment requested on account, $100,000 ex VAT, total interim payment requested 120,000 points of their own.
Huh. So it showed the working for the larger sum, but then explicitly asked for the smaller 120K again.
Exactly. And again, it said payment is due within 14 days. So you have this mix, a clear request for 120K in the email, the invoice, and repeated in the application document, but also a calculation pointing to a much larger potential entitlement.
You can see why Formations might have felt it was ambiguous. But despite any potential confusion, what was the critical thing Formations didn't do?
They didn't respond correctly. They failed to issue any valid payment notice or pay less notice in response to LAPP's application. They were silent, essentially.
And in construction payment law, that silence is, well, not golden.
It's incredibly costly. Because of that failure, LAPP argued their application, the one asking for £120,000, automatically became a default payment notice under the scheme.
Meaning the £120,000 became legally due, just like that.
That was LAPP's argument, and they acted on it quickly. They started an adjudication in November 2024.
Adjudication, that's the fast-track dispute process in construction, designed to keep cash flowing, right?
Exactly. Quick and binding, usually within weeks. And in this case, by December 2024, the adjudicator, Mrs. Grace Chang, found in favor of LAPP.
Awarding the full £120,000.
The full £120,000 plus interest. And she ordered Formations to pay her fees too. And even before that adjudication decision, the High Court had already granted summary judgment for those sums in April 2025, basically a quick judgment saying Formations had no real defense to paying the adjudicated sum.
Now, Formations didn't give up there.
No. They then launched these specific High Court proceedings called Part 8 proceedings. They weren't re-arguing the whole valuation. They were asking the court for declarations that LAPP's original payment application from April 2023 was invalid in the first place.
Trying to cut the legs out from under the whole adjudication decision in the summary judgment.
Precisely. If the application wasn't valid, then no payment was technically due based on it, and the adjudication enforcing it would be wrong.
Okay, so to understand why Formations' silence was so fatal, we need to look at the law itself, the Construction Act.
Right. The Act exists primarily to ensure cash flow. It gives contractors the right to interim payments, and Sections 110A, 110B, and 111 are key.
What do they say in simple terms?
They say the payer must pay the amount notified by the pay unless they issue a valid payment notice, saying what they think is due, or a pay less notice, saying they intend to pay less than the notified sum by very strict deadlines.
And if they miss those deadlines?
Then the amount in the payee's application or default payment notice becomes the notified sum that must be paid.
And because their contract had no terms, the scheme provided the specific rules here.
Yes. The scheme sets out how to calculate the interim payment, basically, value of work done, plus materials, less amounts already paid, and it sets default deadlines. Payment due 7 days after the claim, final date for payment 17 days after the due date. Very prescriptive.
This whole mechanism, pay what's applied for unless you issue a specific notice on time, that's what leads to these smash and grab adjudications, isn't it?
That's the term, yes. Coined, because if the payer slips up on the notices, the payee can effectively smash the door down and grab the cash applied for.
Even if that amount isn't actually the true value of the work done at that point.
Correct. The courts have said it's payable, irrespective of whether or not that sum, in fact, represents a correct valuation of the work to date. It's about enforcing the payment cycle first. The actual value can be sorted out later, perhaps in a final account or another adjudication.
It sounds harsh. Draconian, as you said.
It can be. And because the consequences are so severe, the courts do require the initial application itself to be clear.
How clear does it need to be?
Well, the Kursfield case set a standard. It must be sufficiently clear and unambiguous in form, substance, and intent. It has to be obviously identifiable as a payment application.
Okay, that sounds like a high bar.
And it needs to set out, at minimum, the sum claimed and the basis for the calculation.
So Formations probably thought LAPP's application, with its different figures, failed that test.
That was their hope. But there's another key case, Advanced JV. It synthesized the principles. It stressed an objective approach.
Meaning?
It's not about whether the recipient was confused, but whether a reasonable recipient, looking at everything in context, would have understood what was being asked for.
So step into the shoes of a reasonable person receiving that email and those documents.
Exactly. And Advanced JV specifically warns courts against getting bogged down in nice points of textual analysis or trying to invalidate a notice on some artificial or contrived basis.
It pushes for a common sense view.
A common sense, practical view, yes. Does it make tolerably clear what sum is being claimed and why? That's the essence.
Okay, so armed with those legal principles, how did the judge, in this case, Formations v. Lapp, assess Formations' arguments against LAPP's application? Remind us what Formations argued again.
They had 4 main points. 1, it wasn't a proper interim calculation under the scheme's formula.
2, it was ambiguous that $341K total due versus the $100K on account request, which they called an arbitrary sum.
3, the payment due within 14 days stated by LAPP didn't match the scheme's timing.
And 4, the whole thing was labeled provisional and subject to adjustment.
Right, those were their pillars.
So how did the judge knock them down, so to speak? Let's take the first one, the calculation.
The judge disagreed. He found LAPP did set out the scheme's calculation value of work less payments received, arriving at that $341K figure as total payment now due.
But they only asked for £100.
And the judge said asking for less than that calculated amount didn't invalidate the application at all. He called it realistic and commercially prudent.
Almost suggesting it would be weird to penalize someone for asking for less than they might be entitled to.
Exactly. He actually said it would be absurd if asking for less invalidated the claim. So point 1 failed.
Okay. What about point 2, the ambiguity between the 341K and the 100-pound request?
The judge saw no real ambiguity in what was being claimed. LAPP clearly sought £100,000 plus VAT, $120K total. That was explicit in the email, the invoice, and repeated in the application document itself.
Even though the valuation pointed higher?
Yes, and the judge noted the valuation provided was detailed, so detailed, in fact, that Formation's own quantity surveyor managed to raise 31 specific queries on it.
The fact they could query it in detail undermined the idea that it was too ambiguous to understand.
Precisely. It served as an adequate agenda for an adjudication or discussion. So, point 2 failed.
What about the payment dates being wrong? According to the scheme, LAPP said 14 days.
The judge essentially said, so what? Even if LAPP got the dates technically wrong compared to the scheme's default dates, that didn't invalidate the application itself.
It might be relevant later, but doesn't kill the notice.
Right. Formations could perhaps have raised it as a defense point regarding when payment was due, but it didn't make the initial application invalid. There's no rule saying the dates in the application have to perfectly match the scheme for the application to be valid. Point 3 failed.
Okay, last one. The provisional and subject to adjustment language. Surely that makes it non-binding.
Not according to the judge. He said calling the valuation provisional didn't invalidate the clear application for £100,000 plus VAT. It was based on a detailed valuation, and the provisional caveats just reflected the reality that final figures are often subject to negotiation.
So it didn't undermine the core claim?
No. The judge felt LAPP was definitely saying that at least $100,000 was due. The provisos didn't negate that clear request. Point 4 failed.
So, stepping back from the individual points, what was the judge's overall take?
He concluded it was just obvious what LAPP was doing. They were making an interim payment application for £100,000 plus VAT. The email said it, the invoice demanded it, the application form requested it.
Applying that common sense approach.
Yes, and specifically warning against getting lost in nice points of textual analysis. Make a practical view. Was it obviously identifiable as an interim application? Yes. Did it set out the sum claimed as due and the basis on which such sum was calculated? Yes. It claimed $120K and provided a detailed valuation, even if that valuation showed a higher potential sum.
It really reinforces how reluctant the courts are to let payers off the hook for failing to issue notices, doesn't it?
Absolutely. They prioritize the cash flow mechanism. If the payee's application is clear enough for a reasonable recipient to know what's being claimed, the burden shifts squarely to the payer to respond with the correct notices on time. Minor imperfections in the application won't usually save them if they fail to do that.
So wrapping this up, what are the big lessons for anyone listening who deals with construction contracts or payments?
Well, this dive into Formations v. Lapp really hammers home a few things. First, clarity and diligence are crucial. Understand your contract terms, especially payment terms.
And if there are no terms, understand that the scheme will apply with its strict rules.
Definitely. Second, the UK payment regime is deliberately tough to keep money moving. Courts will generally lean towards enforcing payment based on applications, using that common sense objective test. They won't easily invalidate an application on technicalities if the core message is clear.
Pay attention to notices, both sending them if you're the payee and responding properly if you're the payer. Silence is not an option.
It's probably the biggest risk. Missing those notice deadlines is what triggers the smash and grab.
So here's a final thought to leave you with. Think about your own business communications. Not just formal contracts, but emails, applications, invoices. How would a reasonable recipient interpret them objectively?
Could a phrase you thought was just informal, maybe provisional estimate or payment on account, end up having really significant, maybe even draconian consequences down the line if the other party doesn't respond correctly? It's worth considering how clarity or lack of it could impact your rights and obligations.